All right. So today we're going to talk about trial procedure, and I want to go over what's going to exactly happen in your trial, and the degree to which you do certain things in these cases, and the way you do them will depend highly on your judge and on how the lawyers in your case handle it. But I just want to give you the procedure and the steps that you'll go through while you have your trial. The first thing is actually not really technically trial. The first thing is you will have at some point a pretrial meeting. Okay? So a pretrial meeting with the judge to discuss things like what witnesses are showing up, the order in which witnesses will go. You may have discussions about different motions that we'll talk about here in a little bit. But it's really just to make sure that everybody and everything's in line for the trial and that you're ready to go on the day that is scheduled. Here's why. Judges hate trials. The reason judges hate trials is because trials take a lot of their time up. A judge is concerned mainly about their docket. They're concerned about mainly getting through cases. If they can get you to settle or to plea bargain, they would much rather do that than have a trial. So if they are going to have a trial, they want to make sure that the trial, all the pieces of the trial are ready to go, and number one, that you also need to have a trial. There may be a motion you can file to get rid of a trial. So, Ms. Robbins, do we need to talk about motions and such like that?
Yes.
Okay, so the first one I want to talk about is an MSJ. It's a motion for summary judgment. Summary being spelled this way. I should have just said it this way. Summary judgment. Basically what this motion is, it's under Rule 56 of the Ohio Rules of Civil Procedure. It says this. If we take all the facts as alleged, and all the evidence that's been drawn up in this case to this point, if we assume that the party against whom this motion is being made, either whether it be the plaintiff or the defendant, if we assume that they're absolutely correct, you're arguing that they still lose. So, for instance, if I'm the plaintiff and if I'm the defendant and Ms. Robbins has sued me, I'm going to say in this motion, I'll say, look, under Rule 56, we're going to assume that everything cuts her way under the evidence we have. Even if that's the case, she still loses the case. What motion for summary judgment is saying is, look, the judge has a right to render a judgment now, and we don't even need to have a trial. Okay? That's one. Another one is a motion to dismiss. And by the way, all these things I'm talking about, guys, are motion practice. It's things that lawyers do in motions to try and refine the issues for the court, to refine the evidence for the court, and make sure that the court is as focused as possible during its trial so that there doesn't have to be any time wasted. All right? Motion to dismiss essentially is this. If Ms. Robbins sues me again, right, we have to make sure that Ms. Robbins has filed a claim that actually, under our law, allows her to be paid. So what we do is we look at her motion, we read it as it is. I'm sorry, not her motion. We take her complaint, and we say, look, we look at her complaint, we say, look, if everything's right as she says, does it create a claim under law? If it doesn't create a claim under law, I can bring a motion that says it doesn't count. This case has to be kicked out, or the claim has to be kicked out. And there's no argument. It's not a claim under our law, and away it goes. Ms. Robbins, am I doing fine on time?
Yes, you are.
Okay. The other one I'm going to go over now, and we'll talk a little bit more about this later, all right, is a motion in limine. A motion in limine is to exclude certain evidence from trial before the trial ever happens. What you don't want is a jury or a judge to see evidence that could affect their decision-making without... You don't want them to see that. So what you don't want them to see that evidence, so what you do is you try to exclude it in advance. The best way to probably talk about this one is for me to give you an example, okay, how it worked in my practice. One of the last cases I had, I've told probably all to you guys when you were freshmen, I called it my squished guy case, and that's not a very nice way to call it, but it's a good way to remember it. A gentleman stuck himself inside of a machine that was probably half the size of this room. It opened up in the middle, and what he did, he just made a mistake. He forgot where he was, didn't think about the dangers. He set himself in the machine, and he got himself squished here, from here on up. Probably made him about the size of as wide as a phone book, and that was it. His family sued us for wrongful death. much like in the OJ case, family sued us for wrongful death, so my client, claiming that my client hadn't properly trained him and had not properly warned him about this danger before he got involved in this. Okay? So now we get to where the motion in limine matters. There were pictures taken of this guy, of the accident scene. Pictures of him taken. There were pictures, autopsy photos of him. And what happens when a body dies is the body starts to create gas. And bodies that create gas and have been squished create gas in all kinds of odd pockets. And he looked about as gruesome as a person could look. It was as bad as you can be. Okay? I filed a motion in limine. My motion in limine was before the trial ever happened was to say, look, there's a rule under Ohio evidentiary rules that says, look, if evidence is prejudicial, even if it's relevant, even if it would help determine a fact in the case, if it's so prejudicial that the fact finder, meaning either the judge or the jury, can't render a fair decision if they're shown that evidence, then the evidence can be kicked out. And my argument was, once you show these gruesome pictures to a jury, the case is over. I can't render any, they will hear no arguments. All they'll want to do is help out the plaintiff, who was gruesomely injured. There's no argument about that. He was killed and looked bad in the process. Guys, to give you an idea, these photos were so bad that I put them in a folder, and I forgot to tell my paralegal that they were in the folder. She went and opened the folder, and I found her passed out because she's looked at these pictures. These were bad. The judge agreed with me. And guys, when we got that evidence kicked out and a motion in limine, the other side decided that they were done because they knew that their case wasn't that strong. The only thing they really had was they had the feelings of the jury and the emotion of the jury, and so they decided to drop the case. We settled for a minor amount. That decided the case. All right? How does this affect you? There are provisions of Ohio evidentiary code that we're going to go over later that you're going to want to look at as lawyers to make sure there aren't some pieces of evidence, witnesses, parts they might talk about, documents, things like that, that can't be shown to the jury because they violate the rules of evidence. If they violate the rules of evidence, they don't come in, and you don't want to argue about that in front of the jury. You want to argue about it in front of the judge at trial. You want to argue it before the case ever comes to trial. So those are 3 examples of pretrial motions that you can render. Want to hit that? Mm-hmm.